16 states, led by New Jersey, have sent a letter to the United States Court of Appeals for the Fifth Circuit objecting to the return of force reset triggers to their owners. Let's go ahead and talk about it. What's up, Wolverines? Today we're going to be talking about 16 states trying to buy time. Before we get into that, please sub to the channel, hit that big thumbs up if you like what I do here, and leave me a comment down below so I know you're not a bunch of bots. You can also support my work by heading over to johncrump.locals.com and joining up. The next 5 paid members will get a signed copy of my book, Masters of Firepower. It's my way of saying thank you. And one more thing, this video is made possible by our friends over at X-Tech Tactical. They make the sickest mags on the planet. Their mags are proven to work in real world situations. This is my favorite AK mag. It is made by X-Tech. It is phenomenal. You pay for quality and you get quality. But we have a deal for you. Use code CRUMP10 and get 10% off your entire order. That's an amazing deal. Now let's talk about this dumbass letter. There are 16 states that are trying to stop or at least pause the return of force reset triggers. Of course, New Jersey is leading the fight because why wouldn't they be right in there trying to subvert your rights? They claim that the return of the triggers presents a significant and irreparable danger to the public. Funny how I can't find a single crime that used an FRT. The states also acknowledge that they are not a party to the case, meaning that the courts are under no obligation to even consider any of their phony arguments. Let me read you what they are saying. The letter reads, amici states right to notify the court that appellants have begun the process of returning confiscated force reset triggers in light of the February 22nd, 2025 return deadline imposed by the district court in the order on appeal. National Association for Gun Rights v. Bondi. The return of these weapons present a significant and irreparable danger to public safety and underscores the need for a prompt ruling from the court reversing the district court's final judgment and order. Although amici states are mindful that they lack party status in this case, they are writing to appraise the court of this notable development. This kind of smells like the states are trying to ask the Fifth Circuit Court of Appeals to use intermediate scrutiny to stop the triggers returns. You know something that the courts are strictly prohibited from using? Intermediate scrutiny. Intermediate scrutiny weighs the rights of the people against the interest of the state. It is also known as interest balancing. This legal term was used for years to uphold gun laws across the country until the Supreme Court's Bruin decision. In Bruin, SCOTUS said that only the original text, tradition, and history of the Second Amendment from the founding era could be used to determine if a gun law is constitutional. Since Bruin, the courts are no longer allowed to use intermediate scrutiny to justify upholding unconstitutional gun laws. And these anti-gun zealots out there really hate that. The states have also used the excuse of health, safety, and welfare to justify their letter. We have seen these excuses being used in other cases dealing with firearms. And in all those cases, the move failed. Remember the New Mexico case where the governor tried to argue that public health gave her the ability to suspend an American's Second Amendment rights? That didn't work. The law does not have an exception for public health. The Second Amendment does not have an exception for public health. The states complain that they are at the mercy of the federal government's interpretation of their own state laws. They always are. State laws are inferior to federal law. One thing I want to make abundantly clear, the NAGR v. Bondi case is not a Second Amendment case. It is an Administrative Procedures Act case. The plaintiffs claim that the ATF exceeded its statutory power when it designated FRTs to be machine gun conversion devices. An FRT doesn't operate like an MCD described in the National Firearms Act of 1934. The ATF forced a square peg into a round hole to reach its determination. Where have we seen that before? Oh yes, that was the ATF too. The Fifth Circuit has already ruled in a case that made similar arguments. That case was Cargill versus Garland. It deals with the device known as bump stocks that the ATF concluded were MCDs, even though it did not meet the statutory definition of a machine gun conversion device. The appeals court ruled that the ATF exceeded their power and knocked down the rule. The ATF appealed to the Supreme Court, which affirmed the lower court's decision. There is no reason to believe that the Circuit Court will come up with a different conclusion than it did in the Cargill case. The states might be trying to buy time and attempt to amend their laws to block the ownership of FRTs. These states know that this is a losing case. No doubt about it, they know. The writing is on the wall. They are just trying to delay the inevitable. They are hoping against hope because I don't see the Fifth buying anything that they are selling. But I could be wrong. Let me know what you think down below.